Question 919. In the wake of the widespread savings and loan failures of the 1980s, a law abolished the Federal Home Loan Bank Board and created the Office of Thrift Supervision to supervise savings institutions. The new law was called A. the Savings and Loan Rescue Act, SLRA, B. the Thrift Authority, C. the Financial Institutions Reform, Recovery, and Enforcement Act of 1989, FIRREA, D. United States Savings Bank Central Command. Correct answer is C. the Financial Institutions Reform, Recovery, and Enforcement Act of 1989, FIRREA. The act was utilized after the subprime mortgage crisis to make it easier to prosecute banks which misrepresent the quality of their loan portfolio. Question 920. The following written instruments are contracts, except A, N, A. Mortgage, B. Exclusive authorization to sell listing, C. Escrow instructions, D. Quitclaim deed. Correct answer is D. Quitclaim deed. A quitclaim deed, as well as any other type of deed, is not a contract. Question 921. Acting on behalf of more than one party involved in a transaction is A. illegal, B. permissible, if properly disclosed and agreed to by the parties, C. unethical, D. renders the transaction voidable. Correct answer is B. permissible, if properly disclosed and agreed to by the parties. Note that failing to disclose such a dual agency violates the real estate law. Question 922. Which of the following would not be paid by escrow disbursements? A. hazard insurance, B. real estate taxes, C. mortgage insurance, D. personal taxes. Correct answer is D. Personal taxes. Personal taxes are never paid from escrow accounts. Question 923. 4 persons owned equal interests in a large vacant lot as tenants in common. One of the co-tenants decided to lease the property to a developer planning to build a high-rise apartment building. The lease between that co-tenant and the developer is A. valid and binding on the other co-tenants, B. valid, provided that the lease does not exceed 70 years, C. invalid, as one co-tenant cannot obligate the other co-tenants for a lease of the whole property without their consent, D. invalid, and not binding on the other co-tenants since land owned by co-tenants cannot be leased under any circumstances. Correct answer is C. invalid, as one co-tenant cannot obligate the other co-tenants for a lease of the whole property without their consent. While one tenant in common with an interest in real property could enter into a valid lease involving just her share, that co-tenant could not obligate the other co-tenants for the whole property without their approval. Question 924. Roof types include the following, except A. gambrel, B. mansard, C. Tudor, D. gable. Correct answer is C. Tudor. Tudor is a particular style of home architecture, characterized by their steeply pitched gable roofs. Question 925. A broker must retain copies of his real estate accounts and records prepared or obtained by her, including listings and deposit slips, for a minimum of A. 1 year, B. 3 years, C. 5 years, D. for the duration of his brokerage career. Correct answer is B. 3 years. The Business and Professions Code Section 10148A states that a broker must retain such records for 3 years and have them made available for inspection by the Real Estate Commissioner upon proper notice. Question 926. Wood frame houses, the material that is most commonly used for home construction in California, are most susceptible to damage by A. wind, B. rain, C. termites, D. coyotes. Correct answer is C. termites. Termites cause billions of dollars in damage to homes every year. In California, home lenders require pest control inspections primarily looking for termites. In some termite-prone areas of the state, pest control inspection is required by the FHA and VA. Question 927. Those parties judged to be incompetent and so without the capacity to contract include A. the insane, B. Minors. C. Those with guardians appointed by the courts. D. All of the above. Correct answer is D. All of the above. Someone who is senile or intoxicated at the time of signing a contract would also be considered legally incompetent. Question 928. What happens to the agency relationship created by a broker accepting a listing if the broker dies? A. The listing remains effective. B. A new broker chosen by the broker's agency will assume the listing and the agency. C. Both A and B. D. The agency immediately terminates. Correct answer is D. The agency immediately terminates. A listing agreement is considered a personal services contract since a broker agrees to provide services for a seller. Since an agency is a contract for personal services, death or incapacity of the client or broker terminates the agency relationship. Question 929. An agreement that creates a leasehold estate which ends more than a year after the date of the agreement must be A. Recorded. B. In writing. C. Arranged by an attorney. D. Valued at more than $1,000. Correct answer is B. In writing. Even if the term of a lease is less than a year, the agreement must be writing if the lease will terminate more than a year from the agreement date. Note that only the landlord is required to sign the lease. The tenant can agree to its terms simply by taking occupancy. Question 930. A broker becomes aware that his listed property has large structural damage due to an earthquake that occurred 4 years ago. While showing the property to a prospective purchaser, the broker A. must tell the buyer because the broker has a duty to disclose all material facts. B. does not have to tell the buyer because his duty to disclose does not extend to the buyer. C. does not have to tell the buyer because the house is being sold, as is. D. does have to tell the buyer about the earthquake if the buyer is not aware of it, but not about the damage. Correct answer is A. Must tell the buyer because the broker has a duty to disclose all material facts. A real estate licensee must reveal all material facts, defined as something that would influence a party's purchasing decision, such as massive structural damage, or any other defect of which the licensee is aware but would not be apparent to a reasonably prudent person.